Hi, welcome to Commercial Law Tutorials. So, what are the essentials of a valid contract? The first one is there should be agreement. Then the second one is legality. Next, contractual capacity. Then necessary formalities should be upheld. Next, performance must be possible. And then there should be serious intention to contract. And lastly, agreement must not be vague. Let us look at the essentials in detail. The first essential we are going to look at is agreement, or offer must be communicated. An offer must be communicated to the person with whom it is intended that contractual relations should arise. The general principle is an offer has no force or effect until the offeree knows of it. The offer may be made to a particular person, a group of persons, or the whole world. Valid acceptance then turns a valid offer into a contract. The acceptance of the offer must be in the manner and mode prescribed by the offer. That is, silence does not amount to acceptance. Where offer prescribes the mode or method of acceptance, in this situation, any acceptance by any other method will not create a contract since the parties will not be in agreement. The general rule is a contract is concluded the moment that an offer is accepted, provided the other essentials of a contract are present. So, as I have said before, a detailed lesson on offer and acceptance is in our next lesson. Here I've just given you the summary. Let us look at this case. An offer by Ellison to buy flour from Henshaw was brought to Henshaw by a wagon. In terms of the offer, it was required to send his acceptance to Ellison by means of the wagon. Henshaw, thinking he could reach Ellison more quickly by post, accepted by letter, which arrived after the wagon. It was held that the acceptance was invalid and there was no contract. Why? Because we have said the offer should be accepted in the prescribed mode or way. Any other mode of acceptance does not lead into a valid contract. So let us move on. The next essential is there should be serious intention to contract. An offer must be firm. The offer must really mean business. The offerer must not simply make a tentative statement of willingness to do business, but must make his offer specific with the intention that a contract is created. For example, offers made jokingly do not form a contract. Additionally, an offer which leaves certain terms to be discussed at a later date does not lead to a binding contract. It is not a complete offer, as happened in the case of OK Bazaar versus Bloch. In this case, there were prolonged negotiations for the sale of shares. One of the parties suggested that they had argued over the matter for too long and said, let the two attorneys wrangle between themselves as regards to the terms. There was no mention of payment or price and mode, that is, the basic elements were missing. So it was held that the bargain was not final and complete. There was no contract at all since terms had not been defined. They were just talking. Next, the contract must be executed or put into writing. The general rule is that no formal terms are needed when contracting, provided the parties' intentions are clearly communicated by the one to the other. An agreement by word of mouth is perfectly valid and enforceable. But by statute, however, some contracts are void if they are not made following the necessary formalities. Formalities are strictly required for the formation of these contracts, provided other requirements for validity are met. These contracts include hire purchase agreements, insurance, mortgage bonds, anti-nuptial contracts, apprenticeship, share transfers, pre-incorporation contracts, registered leases for 10 years or more. The formalities we are talking about include writing. A written contract is an agreement made on a printed document that has been signed by parties. Written contracts are legally binding and easier to enforce than oral contracts. Where the parties agree, either orally or in a written agreement, that there shall be no contract unless it is in writing and or is signed. Absence of such written agreement or signature voids the contract. Hire purchase requires writing. If hire purchase is done without writing, it is treated as a credit sale. It will no longer be treated as hire purchase by law. So hire purchase contracts should be executed. Notarial execution. A written contract written before a notarial public, for example, trust, that is the other formality. Then the last one is registration. Registration is the act or process of entering information about something in a book or system of public records, that is, in a register kept by the state. Contracts that are registered include marriage certificates. The next essential is the agreement must not be vague. The general rule is that an agreement must not be so vague that its meaning cannot be ascertained by a court. The mere fact that a contract appears to be incomplete or uncertain does not render it void for vagueness, if its meaning can be determined by a court on the evidence before it. If the court can determine its meaning, the contract is valid though incomplete. But if the court cannot interpret the contract is void. If the contract is too vague and uncertain to be interpreted by the courts, the contract is surely void. The agreements which are vague and not certain enough to be enforced by the courts fall into three major classes. Those where the contract depends upon a condition that the promisor will be bound if he wishes to do so. It has an unlimited option to the promisor. For example, in this case, Towet wished to claim in a declaration in a divorce action for payment of an amount under an antenuptial contract, which provided that her husband undertaking to give seed to her as a sole beneficiary of an exclusive property or wedding gifts, presents, and donations, as also all furniture which he may now or hereafter acquire, at such a time or in such quantities as may seem to him, to the value of 500. It was held that the promise in the antenuptial contract was too vague to be enforced. The second class is of those contracts where the language used is so vague and uncertain that it cannot be decided what was in fact agreed upon by the parties. For example, in this case, a contract between the parties by which a debt was acknowledged and certain property pledged, provided that the debtor hereby undertakes to pay off a substantial sum every year. This stipulation was too vague to be enforceable in law. It seems impossible to say what is the meaning of the word a substantial sum. No one knew that sum. What was it really? So the contract was held to be too vague. The last class is where contracts have the agreement which are not final and there are still terms to be negotiated, the contents of which cannot be determined. For example, in this case, Bennett was employed as manager at a monthly salary of 40, plus a small commission to be agreed at a later date between the parties. He was dismissed before an agreement had been reached as to the commission. He sued the company at the rate of 1/5%, which rate he contended was reasonable. It was held by the court that it seems impossible to say what is the meaning of the word small commission on the turnover. The agreement was too vague to enforce. Now, how do courts interpret the written contracts? We are going to look at the interpretation of written contracts. To interpret means to determine or ascertain the meaning of the particular word or the grammatical construction of the sentences in a contract, hence finding the sense of the document. But where the meaning is vague and ambiguous and the court seek to determine the uncertainty, it is not always easy to arrive at this intention of parties. However, several rules which assist the courts in their tasks are as follows. Words are to be given their plain, ordinary, and popular meaning unless it appears clearly from the contract that both parties intended to allow a different meaning. Secondly, when a contract is capable of more than one meaning, the court will place construction upon which upholds the contract rather than that which makes it illegal or void. Then an ambiguous clause is interpreted in such a way to bring it into harmony with the whole of the document. In other words, the contract must be interpreted as a whole. Number 4, where a later provision in a document qualifies an earlier one, that is, where written words are inserted in a printed or typed document and there is conflict, the written words are to be preferred. But when all the ordinary rules of interpretation we have been talking about have been exhausted, in an attempt to arrive at the true intention of the parties, the court now uses the rule. The rule is that, if ambiguous, be read against the party who was responsible for the insertion. Now there's this other rule which is also used by the courts while trying to interpret and find the meaning of contracts. The rule is called the parole evidence or integration rule. The general rule of this parole evidence rule is that where a written contract is being interpreted, no oral evidence may be received by the court which tends to contradict, alter, add, or vary the written terms. Exceptions of parole evidence rule are that, except that where ambiguous words are used in a technical or special sense, other evidence is given to explain the meaning of those words. Where the written contract does not show the intention of both parties, oral evidence is also given. And in the case of fraud, misrepresentation and duress, oral evidence can also be accepted by the courts. That was all on that essential. Now let us look at performance. Performance must be possible. Agreement must be one for which performance or non-performance is in the future. One cannot enter a contract to perform in the past, like last year. It's impossible. But performance is always for now or future. The general rule is that a contract is void if at the time of its commencement or conclusion, its performance is impossible. So if a contract becomes impossible of performance after it has been entered into, the contract is extinguished as soon as it becomes impossible and there can be no future breach of it. Supervening impossibility must arise as a result of this measure, that is the act of God or the act of state, which are beyond the control of either parties. If impossibility is due to the deliberate or negligent act of one of the parties, the contract remains binding. Relative impossibility, that is partial impossibility, does not render the contract void, where performance is impossible for the promiser, but not for everyone. The contract is still valid. If the impossibility is within the contemplation of the parties, as for example, in the case of speculative contracts where a scarcity or article sold is expected to be running to the point of absolute, the contract is not terminated by the fact that performance becomes impossible. One can claim damages for breach of contract. So we are saying supervening impossibility must arise so as for a contract to be rendered impossible of performance and to be declared void. Otherwise, negligence, relative impossibility, or speculative contracts do not render a contract void. For example, if a house which is left unattended by a lessee is destroyed by the fire without the fault of the lessee, the lease agreement ends immediately. For example, if the fire is caused by lightning, that is vis major, the lessee should stop paying any further rent. But if the fire is due to the negligence of the lessee, the lease continues and he remains liable for rent accruing after the fire. Even if he doesn't stay in that house, he should pay rent. So where one party proves that the contract has become impossible of performance, the whole contract comes to an end. Note that performance can be to perform an act, not to perform a certain act, to deliver a thing, or payment of money. This is all performance. Now, agreement must be lawful. That is our next essential.